Picture this, handing someone a $20 bill with no instructions. That money could be used for anything, snacks, lottery ticket, or even a beer. Now picture handing someone that same $20 bill and saying, use this to buy lunch. Everything changes. That's the cleanest way to understand what a trust actually is. A trust is simply an asset with an instruction. That one idea, assets plus an instruction, is the foundation for how trusts work in estate planning. And once you understand it, a lot of the mystery that shrouds trusts will disappear. Many people assume that a will is all they need. And for some situations, a will may be sufficient. It outlines your wishes for what happens to your assets after you have passed away. But here's what people don't understand and don't realize. When you pass away, your will must go through a court process called probate. Probate can take time and often comes with fees, and the entire process is public record. A trust also directs what happens to your assets when you pass away, but it bypasses the probate process entirely. That typically makes the process faster, more efficient, and private. For families who value continuity and discretion, it can be a meaningful difference. Now, here's a scenario people often overlook in estate planning. It isn't only about what happens after you pass away, it's about what happens if you are alive but become incapacitated. In that situation arises, a trust may allow for an alternate trustee to step in and manage your assets and other affairs, either on a temporary or permanent basis. From a practical standpoint, this tends to be a smoother process than relying solely on what is known as a power of attorney. Your financial life can continue without disruption and without requiring court intervention. Here's another factor that trusts address: helping to protect the beneficiaries from themselves and from others. If you leave money directly to a child or grandchild, that money is immediately in their name and fully accessible. Keeping assets in trust may help guard against things like reckless spending or financial immaturity, substance abuse challenges, predatory relationships with financial exploitation, divorce proceedings, legal judgments against them. Keeping assets in trust rather than leaving them outright may help shield those funds and the person while still supporting the beneficiary's health, lifestyle, and well-being on your terms. Now let's talk about the types of trusts. There are basically two fundamental types of trust. Revocable trusts. These are created and managed by you during your lifetime. You can change, update, revoke the trust at any time for any reason. This is the most commonly used foundation for estate planning. The next are irrevocable trusts. These generally cannot be changed once they are established. These types of trusts may be used for more advanced estate planning and are often created within a revocable framework after the grantor, the person that created the trust, has passed away. Neither type is right for every situation. Trusts aren't a one-size-fits-all, but for many families, they serve as a tool for privacy, continuity, and control. If you're thinking about whether a trust makes sense for your situation, an experienced estate planning attorney working alongside your financial advisor can help evaluate whether trust-based strategies align with your broader goals. At HighTower Westchester, we collaborate closely with estate planning attorneys to help our clients build plans that reflect what matters to them. If that's a conversation you're ready to have, we're here to help.